If you share a joint bank account with your spouse, you probably assume you'd still have full access to it if they passed away. For most couples, that assumption is actually correct, but for a surprising number of families, it isn't, and they don't find out until they're standing at the bank counter, trying to pay for a funeral with no access to their own money, at the exact moment they can least afford that kind of delay. Everyone assumes marriage automatically protects joint money. It doesn't always. The specific way an account is titled, a single missing document, or even just the bank's own internal caution, can freeze money that legally belongs to you. And this rarely happens because of anything you did wrong. Most people find out about this rule the hard way, during the worst week of their life instead of ahead of time. In this video, I'm going to explain exactly when joint accounts stay accessible after a loss, when they don't, the specific account title that catches people off guard, a hidden risk that exists even while both spouses are alive, and exactly what to do right now to make sure this never happens to your family. By the end, you'll know exactly where you stand, and exactly what questions to ask your own bank this week. Quick disclaimer first. I'm not a lawyer, a banker, or a financial advisor. This video is educational only based on general banking and probate information. Always confirm your specific account details with your bank, and if needed, an estate attorney. My name is James. This channel breaks down exactly how banking, Social Security, and IRS rules affect your money in retirement every single week. If that's useful, subscribe now. Next week, I'm covering a related mistake involving beneficiary designations that catches even more families off guard. Quick question. Do you know exactly how your joint account is titled with your bank? Type yes or no in the comments right now. Let me introduce you to Carol. Carol and Frank were married for 32 years. They had one shared checking account they used for everything: groceries, utilities, the mortgage, decades of ordinary life running through that single account. Frank passed away suddenly after a short illness without much time to prepare their finances together. Carol assumed she'd still have access to their money the next morning, exactly like she always had. What actually happened surprised her completely. Here's the first thing to understand. Most spousal joint checking accounts are set up with something called rights of survivorship. That's a legal structure, meaning the surviving owner automatically becomes the full owner of the account the moment the other person passes away. In this setup, the account technically doesn't need to freeze at all, and the money never legally becomes part of the deceased spouse's estate. The surviving spouse simply needs to bring in a death certificate so the bank can update its records and remove the deceased person's name from the account. Here's the second thing, and this is where Carol's story gets complicated. Frank also had a separate personal savings account opened years earlier before they even met, still sitting only in his name. It wasn't a large amount, but it was still real money. Carol wasn't listed on it at all. The moment the bank learned of Frank's passing, that account froze completely. Not temporarily, completely. Nobody could touch it, not even Carol, until a probate court appointed her as the legal representative of Frank's estate. That process is called getting letters testamentary if there's a will, or letters of administration if there isn't one. It typically takes anywhere from 2 to 6 weeks, depending on the state and how backed up the local court is, and the bills didn't stop arriving in the meantime. Here's the third thing, and this is the specific catch that surprises even people who thought their accounts were properly joint. Not every joint account automatically includes rights of survivorship. Some accounts are set up instead as tenants in common, a less common but still real designation. Under that structure, the deceased owner's share of the money doesn't automatically pass to the surviving owner at all. Instead, that portion becomes part of the deceased person's estate, and it has to go through probate just like a solely owned account would, even though both names were technically on the account the entire time. Most people never check which version they actually have, because at account opening, banks rarely explain the difference clearly. Frontline staff often don't ask, and both versions simply get filed away and called a joint account. Here's the fourth thing. Even with a properly structured survivorship account, banks can still cause delays. If the bank isn't formally notified of the death right away, or if there's any red flag, a dispute between family members, unclear documentation, suspicion of fraud, some banks will temporarily freeze the account out of caution, even when the surviving spouse legally has every right to that money. This is usually resolved quickly with the right paperwork, a death certificate, and proper identification. But it can still create real stress during an already difficult week, especially if it happens right when bills or funeral costs are due. Here's the fifth thing, and it's important even while both spouses are alive, not just after a loss. Joint accounts come with a hidden two-way risk that many couples never think about. If either account holder has a debt, an unpaid loan, unpaid taxes, a judgment against them from a lawsuit, creditors can sometimes reach into that shared account. Because legally, both owners have full access to every dollar in it, regardless of who actually deposited the money. That risk exists the entire time the account is open, not just at death, and it's worth knowing about long before it ever becomes a problem. Let's put Carol's full picture together. Her shared checking account with Frank had rights of survivorship, so it stayed fully accessible to her once she provided the death certificate, without a single day of interruption. Frank's separate personal savings account, held only in his name, froze completely and required roughly 5 weeks of probate before Carol could access a single dollar of it, all while funeral costs and mortgage payments kept coming due. 2 accounts, 2 completely different outcomes based entirely on how each one was titled years earlier, long before either of them thought about a moment like this. To be fair, most banks aren't trying to make this process difficult on purpose. Freezing accounts exist to prevent fraud and unauthorized withdrawals during a genuinely vulnerable moment, protecting both the family and the bank from legal complications down the road, especially in cases involving disputes or unclear ownership. The frustration usually comes from families simply not knowing the rules ahead of time, not from the bank acting unreasonably or with any bad intent. Here's a detail almost nobody checks until it's too late. Even on a properly structured survivorship account, if the deceased spouse's social security number was still linked to any part of that account for tax reporting purposes, that specific detail can also trigger a temporary review once the Social Security Administration reports the death to other federal databases, adding a short additional delay, even on accounts that are otherwise completely fine and legally already belong to the surviving spouse. Here's one more thing worth knowing, specifically about how quickly banks actually learn about a death. Sometimes a family notifies the bank directly with a death certificate right away. Other times, the bank finds out later through automated government reporting systems that flag social security numbers of the deceased. When that second scenario happens, the freeze can come as a complete surprise weeks after the funeral, when a family assumed everything had already been handled and settled. So here's exactly what to do. First, call your bank this week and ask directly, in plain language, whether your joint accounts include rights of survivorship, not just whether they're joint, because that single word makes all the difference in a moment of loss. Second, check every account either spouse holds individually and consider whether it should have a payable on death designation added, which lets money pass directly to a named person without going through probate at all. Third, keep a simple written list of every account, its type, and where the paperwork is stored, so whoever needs it isn't searching for answers during an already overwhelming time. Fourth, if you're not sure what type of account you currently have, ask the bank to put the answer in writing, rather than relying on a verbal answer from a teller who may not know the details either. If this helped you understand something you'd never thought to check, share it with your spouse or family member this week, because most people only learn these rules after they've already lost someone. Drop a comment letting me know if you've checked your own account titling. I read every single one. If this helped you, hit like and subscribe, because I cover exactly this kind of practical financial protection every week. I'll see you in the next one.